Hello to all of you. We are starting a new edition, another edition of our Câmara Talks, now the Chamber Talks, our very first webinar in English. And we are very happy to discuss a hot topic, a very important topic on arbitration and for dispute resolution in general, which is the topic of evidence. So today's show is about evidence and international dispute resolution. And in the name of the Chamber of Mediation, Conciliation, and Arbitration, Fiesp, I'm very happy to have four great names, four great practitioners here discussing the topic with us. So we have Kabir Dugal, who is advisor at Arnold Porter and lecturer in law at Columbia Law School in New York. Eric Navarro, who is a federal judge here in Brazil and holds a PhD from the State University of Rio de Janeiro in collaboration with Harvard Law School. Maria Cláudia Prokopiak, who is an attorney at Prokopiak Arbitration and has a DEA from the University of Paris too. And João Marçal Martins, who is an attorney at IELTS Checker in cooperation with Mayer Brown and holds an LLM from the University of Pennsylvania. So Kabir, Eric, Maria Cláudia, and João, thank you so much for accepting our invitation. It's a pleasure for our chamber to have all of you here. I'm sure we'll have a very good afternoon and learn a lot about international dispute resolution. So I would like to go straight to our first question, and I would commence addressing that to Kabir, which is about common law and civil law approaches to evidence. In international arbitration cases and international cases in general, we get more and more lawyers, practitioners, and parties from different legal cultures, and it does have an impact on the way evidence is presented, on the way the whole case is led by the parties and arbitrators. So Kabir, I would like to hear you on the topic and to know which is this extent of this impact and how we can address the issue in international cases. Thank you so much.
Thank you, João. I'm delighted to be here. I wish I was there in person with all of you. That is not going to happen anytime soon because of the reality we are in. But I'm still very delighted to get to know all of you. I'm also very grateful. This event has been very well publicized. There's been a lot of interest, and I commend the Brazilian community that takes a topic like evidence so seriously. So bravo. Personally, these days, shaving has become optional, showers has become optional. So anything that can help me get ready, good job. Your question is a great one. You're asking differences between civil and common law countries from an evidentiary perspective. And let me just start off by saying the fundamental starting position for civil and common law countries are different, right? In common law countries, the presumption of evidence is what you would call, I'm going to use fancy terms, but they sound fancy, they're very easy to understand. The system is adversarial, and by that we mean parties, the claimant and the defendant, are responsible for the entire evidentiary process. They are going to fight with one another, fight through arguments, hopefully not through physical violence, but that's the process. The judge is a more passive participant who is looking at the parties that have the primary responsibility for evidence, the adversarial system. Now, if we compare that with the civil law presumption for evidence, the civil law presumption is generally inquisitorial. We have a judge with us, and I think therefore what I'm going to say becomes significant because in the inquisitorial system, and this has its origins all the way going back to Roman law. So it is a very, time-tested way to resolve your dispute. In the inquisitorial system, the judge has a primary role to resolve the dispute. The judge facilitates the evidentiary process. The parties, the council, of course, has a role to play. In both the systems, all the participants have a role to play. I think the difference is who has the primary responsibility, right? And civil law countries, I'm treading very carefully because I'm speaking to an audience where a lot of people have a very firm background in civil law. But the system is generally, you have to prove the evidence to the satisfaction of the judge, right? It is the personal satisfaction, the inner conviction of the judge. So you have these two very different models. Now, since you asked us about common law, João, with your indulgence, may I take 5 minutes just to talk about evidence in the United States? Okay, perfect. Now, this may be a little interesting for you because the way common law countries, right? Just like the word civil law, common law is a very loaded term and it includes a lot of countries. And this is the wonderful thing about being different countries. Every country does something slightly differently. So within the common law realm, the UK and the US, we are separated by English language, but we're also separated by how we collect evidence. The US probably becomes, based on how you see the world, either the best example for taking of evidence or the worst example for the taking of evidence. And there are two unique American concepts. Both begin with a D. And the first is called as discovery. Okay? In discovery, what are you going to do? If I am in a case opposite João, I will tell João, give me everything. And when I mean everything, I mean everything. Every email, everything you have in your possession, give it to me. This is discovery, and it's standard in American. The boxes you will get can fill my apartment up. Now, my apartment isn't very big to begin with, but still, having boxes filling your apartment is problematic. And the second thing you will have is depositions. Now, depositions is cross-examining a witness, but not in front of a judge. So you're not going to be in front of Judge Eric. The cross-examination is going to take place in front of counsel. And you will use that evidence when you go to a judge. Now, international arbitration generally frowns upon both discovery and deposition, although if you look at international arbitration practice, we recognize some form of domestic document production. We don't call it discovery, but some limited form of document production. And we definitely have cross-examination in some form before the tribunal. Whether this is a good idea or a bad idea, I leave it for you to decide. We know the advantages. If people get more information, you're probably going to be able to come out with a better decision. 90% of the times, this is woefully expensive and is not going to lead to anything drastic. So we can more or less discern the pros and the cons. The impact you can see in international arbitration could be on the background of your judge. If your judge, forgive me, I should rephrase, on the background of your arbitrator. If your arbitrator comes from a common law background, the common law baggage may impact the way they look at the world. Similarly, if you're a civil law, your training will impact how you see things. I will make one very final point here. Obviously, you have very international people. One example is in our panel, we have Maria Claudia. She is Brazilian who lived in France and the UK. And she probably has this hybrid experience of many realities. And, for her, I think the experience will be very interesting because she straddles so many different jurisdictions. But I just make this general point, if you come from a civil law background, you tend to have a civil law perspective. When you come from a common law, you tend to have a common law, recognizing that our international practice is some weird hybrid of civil and common law. I'll stop here. We can continue the dialogue, but I'll stop here just so others can chime in.
Good. It's a very good overview of, American system rather than common laws. Common law is a very broad term. But now I would like to carry on and pass the word to Maria Cláudia, who, as Kabir just said, is a Brazilian lawyer, but has vast international experience. Now she's living in London, but has practiced in France before. So Maria Claudia, could you please share your views on the topic?
Sure. So first of all, I'd like to thank the Chamber of Ciesp and Fiesp for the invitation. It's a real pleasure to be here. Picking up on what Kabir was just saying, I think a lot is said about international arbitration being how a hybrid system, a mixture of civil law and common law. But I think that when we analyze specifically the presentation of evidence in international arbitration, or at least what is said to be the best practices, we find a lot of these mechanisms or version of these mechanisms that Kabir just described. And I think that we have to accept that maybe the influence of the common law, at least in this aspect of the procedure, seems to be greater than that of civil law. And that comes probably from, Kabir was also explaining the difference of an adversarial system and an inquisitorial system. And I think that if we take, purely international arbitration, if such a thing exists, we are more towards an adversarial system. The arbitrator has very few powers, or a lot less powers than a judge, to go and look for the evidence itself. So, we will have a certain document production phase. We will have cross-examination of witnesses. We have party experts, which is a bit different from our technical assistants in Brazil. We have parties testifying as witnesses. So we have all of these tools that comes from, a more of a common law practice. And I think that all of this, those are all techniques and practices that for us civil lawyers are foreign. They are strange to our way of litigating. But in international arbitration, it was decided that no, are the best practices. And when I say it was decided, it wasn't without any foundation. These are tried and tested techniques, but with which common lawyers are more familiar. And then it's up to us, civil lawyers, to adapt to our way of working, I think, if we want to, do international arbitration. But I also think that many times, we arbitrators and lawyers, we are so used to doing arbitration in a certain way that we don't always stop to question the system. And maybe we should be asking ourselves, for example, does every case deserve a phase of document production with exchanges of read fair schedules? Technical experts, do we really need, 2 rounds of technical experts and then experts examining at the hearing, and then even worse if the tribunal decides to appoint its own expert after all of this? So I think that, this, maybe we should, it's time to ask ourselves if this is the only way to do arbitration, the best way. And perhaps we are coming to a moment in which it is necessary to just return to that original idea of flexibility, which was, which has always been considered as one of the great attractions of arbitration. Now we think the automatism with which we are maybe deciding procedural issues, and especially issues of evidence. And I think that we have several mechanisms and tools at our disposal, to avoid this automatic acceptance of, we have this template procedural orders, everyone received the procedural number 1, which seems to be kind of, variations of the same thing. But, you have, for example, the case management conference. I remember that when it was introduced, for example, the ICC rules in 2012, it was extremely criticized. And a lot of people said that it would just be one more formality. And the ICC arbitration was getting very heavy, and that it was just one more conference, and it wasn't useful. And I think that the practice showed that the critics were actually wrong. I think that nowadays it's simply unthinkable to establish a procedural timetable and set the rules for the production of evidence without having a conference with the parties. So much so that now we are having other variations of this. We have this midstream conferences, which is a version of this case management conference that is happening during the proceedings, and not just at the beginning of the proceedings. Or we have tribunals that circulate to the parties a draft procedural order with, pre-hearing rules, and then have a conference with the parties to discuss the actual rules that will apply at the hearing. So I think that, more than common law versus civil law, which again, it is very important, and I'm not dismissing the differences, because as Kabir said, there is an impact in how cases are handled. And as I said, we civil lawyers need to learn these techniques if we want to, play this game. But what we should strive for, I think, in international arbitration, instead of accepting these template procedures, is really for, a tailor-made proceeding, trying to adapt the procedure to the needs of the case. And I think that as I mentioned, there are several mechanisms out there that are very useful and that should be used and taken advantage of, because they reintroduce this notion of, flexibility and party autonomy, and they offer to the parties a more informal platform to discuss procedural matters with the arbitrators, which, in my mind, really contributes to the efficiency of the process.
I agree with everything you said. Sorry, just wanted to put that for what it was worth. Yes.
Great. Now I would like to put the same question to Eric. But Eric, we heard that we have this split, this divide between adversarial and inquisitorial proceedings. And normally civil law is associated with inquisitorial proceedings. But you are a federal judge here in Brazil. How much of truth is in that statement? I mean, how inquisitorial, how active judges in Brazil are on dealing with evidence, how this fit on the way that court proceedings are normally taken?
Oh, well, thank you very much again for the invitation. Well, I don't know. I think judges in Brazil, they are very, very, how should I say that? Okay.
Awesome is the word we're looking for.
In the first day in my bench, I always did a cross-examination, for example, because it doesn't make sense to ask something to someone and then repeat this to another one. But I think judges in Brazil, they're becoming more and more inquisitorial. I mean, they are interfering more and more in the process and trying to manage the case with the parties. We have now these procedural contracts in the Civil Procedure Code that judges are using a lot, and there are a lot of discussion if this is a judicial role or just a tool to be used between the parties. So this is a very new theme issue in Brazil.
Great. And João, you also have been working abroad, but now you are practicing in Brazil. And how do you see this topic from the lawyer's perspective?
So first of all, thank you so much, João Lessa, for the kind invitation. It's really pleasure to be here alongside with Maria Cláudia, Eric, and Kabir. So going straight to your question about the main differences on the common law and the civil law, as well as the comments made by my colleagues, one issue that is really evident on these differences of the common law and the civil law system, and you know really well because you just defended your thesis on the differences on the discovery and the disclosure. So please be more than welcome to offer your comments as well, João. But one thing that comes to my mind after working in the US with Kabir Dugal for almost a year is the oral evidence. So just slightly changing the topic regarding the documentary evidence, but the oral evidence in Brazilian civil procedure is not well regarded as is international arbitration and in the common law system. So maybe, and we have Eric with us today, it's good to think how we can take this really advantages and good standards of the common law practice regarding the oral evidence. And I can give examples. So Eric just told us about the cross-examination. So of course, it's like really good to have a cross-examination and avoid the unnecessary parrot system of first asking to the judge and then the judge can switch to another question or change the whole question. So it does not make any sense to have examination different from the direct, cross, and redirect. So this is a really good issue that the 2015 Brazilian Code of Civil Procedure adopted. But also, we could also think about, for instance, the witness statements. So why don't we Brazilian practitioners not try to amend our civil procedure laws, and such as the cross-examination that is already in the code, why don't we try to insert the witness statement provision? Because it's so much better when you streamline the issues that the witnesses are going to talk, and you know beforehand all the facts and the issues that will be commented by the witness. So just one quick note, because I know that we have other topics to discuss, but maybe we can think about adding the witness statement to our civil procedure laws.
Good. Well, as João said, it's a topic that I do like to discuss. My general view, João, in the topic is that the way we approach these devices, those differences, they do exist, but it's a bit misleading because we tend to treat common law as a whole block and then civil law as a whole block, and that's not true. When you look into individual aspects of different legal systems, you get all kinds of difference. And it especially bothers me now to take the names of adversarial versus inquisitorial systems, because they have this negative connotation that one of them is a fight between parties, and the other one, the judge is inquisition. It's this, there is a very bad connotation in those words. And in my experience in general, the judges in Brazil, although they do have the power to direct the production of evidence and request, presentation of evidence by themselves, they do not have the time in general to do that in every specific case, just because they have a massive caseload. So, a lawyer who is taking good care of the case will never wait for the judge to take initiative. Will never do that. He will show wherever he can. And also, when you think about adversarial and parties fighting, you have in America, in the UK, a much more cards on the table approach to the issue of evidence. You have to show whatever you have. If that's favorable or not to your case, you still have to share that with other parties. And in general, in Brazil, you would not be expected to willingly, without being requested. I'm not saying requesting, blocking a request for evidence. That's not what I'm saying. But no lawyer is expected just to hand over, bad evidence in that sense. So what I think in general is that these general conceptions, they do not show specifics, and they just have a more academic value rather than anything on telling what we do on a daily basis. And surely on arbitration in international cases, and here we see several of those in the Câmara Ciesp, Fiesp, my impression is that it's sort of in between. You see some tribunals that are more willing to direct evidence or to cooperate with the parties on the issue, and others will be just more willing to wait whatever is presented. But one thing is a trend, I think, everywhere. That is the whole idea, and Maria Claudia brought that up very precisely, it seems to me. That is the whole idea of management, of someone who's trying to manage the case in the best way. And I think this is true for state judges, and well, from both traditions and international arbitrations. Good arbitration tribunals, they try to manage the case, aiming efficiency, aiming saving costs, and all of that. So I think there's a bit of convergence. It's not that things are going away, but it's going in a way of more efficient proceedings in a sense. But let's go back to our questions, and thinking about the costs and incentives and all that's related to collecting, presenting evidence. I mean, this can be expensive, not only financially, not only on costs, but also on the length of the proceeding, on the strategy of the case. And I would like to address Eric, who studies the economic aspects of civil procedure. Which are the economic aspects that the parties should bear in mind when requesting the production of evidence? What should they be concerned?
Oh, yes. Thank you very much, João. Yes, when we talk about the economics of evidence, thinking about money is a common ground. However, cost with disclosure is not our main topic in economic analysis of evidence. In this expensive and complex environment of international disputes, to obtain an economic analysis of evidence, we have to take a step back and look at the big picture, the incentives around the production of evidence. So I will divide my brief observations in three parts. First, how the incentives for disclosure evidence works. Second, how discovery affects settlement rates. And third, strategic insights in view of disclosure evidence incentives. So first, how the incentives for disclosure evidence works. Well, each part tends to voluntarily disclose favorable evidence because bad news are free. As I said, it's not expected for a Brazilian lawyer to discover evidence against him. So it tends to decrease the other party's optimism. And the other party will also disclose favorable evidence on its behalf. Thus, the average degree of optimism tends to decrease, which will, on the other hand, increase the window, the range of options for the settlements. Second, even though parties want to disclose favorable evidence, sometimes there are incentives to disclosure unfavorable evidence. This follows from a well-known result in game theory called the unraveling effect. This behavior is expected when the party reveals unfavorable information just to show that her situation is not as bad as the other party thinks. For example, the other party thinks that I have breached all the contracts, but I just breached part of the contract, so I need to prove it. So this also tends to decrease optimism from the other party and enables a settlement, which of course depends on the truthiness of disclosure. But it just works if the uninformed party at least knows enough about the existence of the information and its value to be able to make a credible threat to subpoena it at trial. Otherwise, there's no reason to voluntary disclosure. And there is a very important conclusion here. This is my first important conclusion. Mainly considering the well-known debate about the imposition of formal discovery by the arbitrator, even if there is no pre-agreement around it. It is that given the party's incentive to disclose both favorable and unfavorable evidence that they believe will come out at trial anyway, then formal discovery might be most useful as a tool of eliciting unfavorable evidence that would never come out at trial. And it has social value insofar it improves the accuracy of trial outcomes and therefore the quality of settlements negotiated in light of those outcomes. Just to be clear, because I foresee more accurately the outcome of the trial, I tend to align my offer accordingly in settlement negotiation. But on the other hand, disclosing unfavorable evidence will increase the other party's optimism, which in turn will decrease the settlement window. Therefore, the net benefit of formal discovery depends on the mix of information that should be disclosed voluntarily in its absence. Suppose, for example, there is no unraveling in a case. So parties only disclosure favorable information, make the opposing party more pessimist, reducing mutual optimism and make settlement more likely. Adding formal discovery to this setting gives the parties a tool to elicit unfavorable information as well, which might reduce the chance of a settlement by increasing both parties' optimism about their own success. On the other hand, given that formal discovery increases the cost of litigation, it increases incentives to early settlements. All in all, the basic point is simple in the presence of formal discovery. When parties settle before discovery, they settle in light of the expectations about possible discovery results. If one of the parties does not know for sure what discovery will reveal, that party will be in disadvantage in settlement negotiations, and it will be reflected in the settlement, decreasing its accuracy compared to the actual litigation final outcome. In short, it's not clear, at least from the economic analysis point of view, how much benefit a system of formal discovery adds to litigation in terms of social welfare. Even with a discovery, parties have incentives to exchange some information voluntarily. Discovery reveals more information that otherwise would not come out at trial. This might increase or reduce the possibility of settlement depending on the voluntary disclosure baseline. And it all should enhance settlement quality depending on how often cases settle and how much additional pressure discovery creates. But, and I'm finishing, talking about strategy, the main incentive here for parties' behavior is the cost of evidence in international litigation cases. In absence of discovery, there is also an additional cost of party investigation. Parties might resort on sophisticated methods to gain access to secrets, for example. And anticipating this, the potential targets would invest in precautions to prevent disclosure, which might then elicit a counter-response in form of even more sophisticated measures to circumvent these precautions, and so on. And this goes on and on in a wasteful case of, arms race in a typical prisoner's dilemma setting. But in the presence of discovery rules, parties tend to engage in excessive or in an abusive discovery. And the reason why parties engage in excessive discovery is because the party claims the discovery request does not bear the full cost and does not need to pay an opponent's response cost in a typical case of externalization of costs. And abusive discovery refers to discovery practice aimed to impose costs on the other side and leverage a favorable settlement. You know that. And this strategy can also be used by the claimant, but also used by the respondent. So the claimant can file an additional request with a credible threat to enforce it just to impose cost leverage for settlement. And the respondent can always refuse to comply to any request, only to force the requesting party to invest in enforcement. So as you can see, this also leads to an arms race. And again, we have a typical prisoner's dilemma case where the players are driven to a comparative equilibrium that makes them both worse off. Neither side cooperates because it's too tempting to the fact and too disastrous to be the only one who cooperates. So let's finish with some insights about strategic behavior in this setting. First, discovery limits and cost shifting rules are some of the solutions proposed to diminish the problems with excessive and abusive discovery. But from an economic perspective, the challenge is to design a system of limits that strikes the best balance between the benefit of reducing discovery and excess and abuse, or that arms race in investment and litigation, and the cost, and of course the cost of depriving parties of valuable information. And for a party and its counsel perspective, the best rules and the best strategy depends on, first, the amounts and the quality of the evidence they have, and second, their knowledge about the quality of evidence the other parties have. And on this ground, game theory tools that deal with a strategic behavior can be used in a cost-benefit analysis in order to decide between, for example, a settlement or litigation. And the same tools can also be used when the counsels are negotiating an arbitration clause in order to impose or not some kind of on-off discovery. So that was my point of view. Thank you.
Wow, what a lecture on law and economics. Thank you so much, Eric.
No, it's not. Thank you.
But I would like to keep our question and then address it to João Marçal. João, when you are advising a client, what you bear in mind, what you take into account when waiting, a request for evidence or production of new evidence?
João, thank you for the question. So it really depends. I know that it's a common ground answer in law, but again, it really depends, because if your client has a really strong case and it's really hard for, like, when we have like a kickoff meeting with the client. So the first thing that we always ask is, okay, but you have all your documents organized and in a way that we can firstly assess if this, for instance, breach of the contract that you are alleging that your counterparty did has any grounds. So first things first, this assessment and management of documentary evidence is vital for the assessment of the likelihood of success of your client in a case. And if we are dealing with like a expert dispute, a dispute which deals with a really strong case, I mean, depending on an opinion of an expert, we should then assess, because clients love to say, no, I have someone in my company that can be the expert. And our advice is, okay, we understand he can work with us, But let's ask for an independent expert to add and work together with our own experts to really know if what you're saying, if your case is strong or not. And a lot of times, the independent expert, but I'm not talking of the tribunal or the party appointed expert. So before going to the dispute, it's really a good idea to engage if we are having a dispute which deals with an expert issue, to engage this expert, and then after several meetings, and he produces an expert report, we can then have another meeting with the client, say, okay, now that we have all these documents organized, now that we have an independent expert report, we can give you a full assessment on your claims and decide if it's first better to go to a negotiation, a settlement, a mediation, or the filing an arbitration procedure. So all of these options will strongly depend on the assessment on the claims. So as a lawyer, I really prefer to have a client first asking, could you give me a legal assessment before deciding if we should or should not file arbitration, mediation, or whatever. So to straight answer your question, it really depends on how the client is organized. If the dispute demands a legal expert report, and then we will, vis-a-vis with the legal arguments, advise the client if it's better to go to a negotiation or if he should just follow the arbitration agreement or the forum clause agreement and file a lawsuit or an arbitration procedure.
Good. Kabi, I understand that discovery in the US is particularly broad, and there's loads of documents that are normally produced even in a simple case. How this structure of discovery, how does it impact the parties on course, and how it's normally dealt in the US? And
sure, I mean, I think that's a great question. What is the impact on costs? I have to answer this very delicately. It definitely has a huge impact on costs, right? If we're talking about a contractual arrangement that goes back 20 years and the agreement says produce everything, you have to produce everything, including emails, including servers. It's not uncommon, double negative. It's common, positive, to give the server. You just give the server, and it's a very time-tested strategy in the US. To inundate your opposing party with everything. Just do what the technical term for that, I'm using the word technical term loosely, is a document dump. I'm just going to give you everything, figure it out. What tends to happen in practice, and I think this gets to the judge's point, somewhere, probably not as eloquently as the judge explained in terms of the process and the issues, but somewhere in between, there will be a negotiation and a settlement that typically happens. So the process will generally start with parties being very argumentative. You have the document exchange. You realize there's negative things on both sides, and the parties will sit in a room and settle. So very few cases actually enter into the judicial system in a strict sense, But this is the reality of how the process has developed in the United States. Is it the most efficient system in arbitration? Just to take the domestic system and put it into an arbitration context, definitely not, right? We're talking about inequities in parties, inequities in practice. I think Maria Claudia's point generally for us to be thinking about, how can we make the system most flexible? How can we make the process most efficient? Should be our guiding considerations. And I I do think if we get back to first principles, in some cases, having this crazy approach of giving every email may be efficient, but in 99% of the cases, we can safely assume that is not efficient. I also just want to pick up on one point. Again, this had come out from Maria Claudia's initial comments, but I think it is a good one because arbitration does tend to have practices that are common law based. Now we can historically I try to ascertain why that happened. Power tended to move from UK to US, and so the system does tend to have a common law basis. For example, we assume document production will happen. We assume there will be cross-examination, and these are predominantly common law ideas, I do take the point, that we should try to get back to first principles and see what makes most sense, The world is, as you say, becoming more and more harmonized. But I do think the general perspective you should always keep in the back of mind is how do we make our system most efficient? If we keep that in the back of our mind, arbitration will probably achieve a lot better goals. So I'll stop here. I know that was a long-winded answer and I slightly digressed, but I think it was a helpful point.
No, thank you very much for the comments. And now, Maria Claudia, I want to hear your perspective, especially practicing in Europe, and how costs they affect international arbitration regarding to the production of evidence, and if there is a more efficient way in the line of what Kabir just said.
Well, I think that, I worked in private practice for 10 years and I left last year. So now I'm mainly working as arbitrator. But thinking back and seeing, when we used to see whenever a budget completely explodes, when it comes to evidence, there are mainly two culprits. And those were the ones mentioned here, is document production and expert technical evidence, especially in those cases that are very heavily dependent upon technical evidence. I think, at least in my experience, it's very rare to have US-like discovery in international arbitration, but we always have a phase of document production. I think Kabir is completely right. We assume that there will be an opportunity to ask for documents. In that phase, when not limited somehow or controlled, which I think is extremely difficult to do, can really get out of control. I have seen reference schedules of more than 700 pages. And yes, it was one of those very big complex investment/construction cases, but still, is it really necessary? Because when you request 100 categories of documents, normally divided into 5 subcategories, each of them, well, even if half of your requests are granted, only half of your requests are granted, which would not be a great outcome, you will have thousands and thousands of pages of documents that you will need people to review. And we all know that, there are good chances that the vast majority of those documents turn out not to be very relevant. So for me, this is one of the challenges, and I think Eric mentioned this point as well. For me, also in international arbitration, this is one of the challenges that we face now, is how to control these types of situation. How can you allow the parties a full opportunity to present their cases, respecting due process and so on and so forth, but still somehow controlling or limiting their right to request the production of document. And I think that the other aspect that also can become very expensive is technical evidence. And of course, the worst of both worlds is when you have party appointed experts and then the tribunal still decides to appoint its own expert. And I was thinking about this now, and I wanted to share one case that for me is the classic demonstration of how incredible the impact on costs can be. Like when we look at the Ecuador versus Perenco case, the ICSID case, Ecuador versus Perenco, which was an extremely complex case that lasted for more than 10 years. And that itself in the award described as a lengthy, complex, hard-fought, and very expensive case. this is actually written in the award. So the case was indeed extremely expensive, and the amounts in dispute were also, colossal. It was several billions of dollars. But one of the dozens of issues that the tribunal had to decide, and it actually was bifurcated and ran as a parallel arbitration, was the issue of Ecuador's environmental counterclaims against Perenco for environmental damage to the Amazon forest, where the oil blocks operated by Perenco were located. And it was an extremely complicated issue. And before appointing its own expert, the tribunal did render a preliminary decision, basically deciding on the legal framework of the counterclaims. And before deciding on the quantum, it told the parties that certain issues of fact were extremely difficult for the tribunal to make a proper determination, and that there were gaps on the technical evidence presented by the parties, so that the tribunal would have to appoint an independent expert in order to fill these gaps. So it was not necessarily redoing the whole technical analysis. And still, after Perenco had, and I remember very vividly this amount, and they are open, you can find the award online. After Perenco had already spent more than $10 million with its environmental expert, and Ecuador had spent some $4 million with its own environmental experts, the tribunal appointed expert costed the parties an additional $5 million. Now, of course, this is a very extreme example, but it is a real one that I think, demonstrates the issue of how things can really, get out of control when it comes to evidence.
May I make one point here that flows from this very beautiful, I think, exposition? Because I think this is an important point, Definitely tribunal-appointed experts are perceived to be the nightmare situation, right? Because, somehow the control has gone out of parties. I just wonder, though, and this is where, we can potentially see the civil and common law differences in play, and arbitration largely following the common law approach, the adversarial approach, because what tends to happen is sometimes you have these party experts, right? And the experts give their expert opinions. Often it's, in writing, right? Before you come to a hearing and there's some cross-examination. But, the reports can sometimes be like two ships crossing an ocean, right? They can be completely with different assumptions, completely different models, completely different perspectives on how they're looking at situations. And, if you're the arbitral tribunal, right, it's very hard for you because you have two reports. One is apples, one is oranges. How do you compare them? And I wonder, I just put this as an idea, whether it may make sense to have what you had suggested, at some stage, maybe a case management conference, have, a little bit of the inquisitorial, and forgive the words, Joao, with all apologies to you. You have the arbitral tribunal giving some criteria. Let's make your report have assumption A, assumption B, assumption C, do it using this model, this model. Maybe that could be a little better way that you have the parties at least somewhat in dialogue. I just present this as an idea because clearly the Ecuadorian situation was the nightmare situation, right? And I just put this
again, it's not the traditional everyday case, but I think it's a very good example of how things can completely, go off the rails. And the tribunal in this case did, when they rendered a preliminary decision, they did invite the parties to try and settle. But it's extremely difficult for a state to settle an environmental law case. Yes. So there were other considerations. So, it was complicated. But there are lots of tools out there to make things more efficient. You can put both experts together and say, okay, so I want you both to, draw a list of issues that you agree upon and a list of issues that you disagree upon. And then give me the reasons as to why you disagree upon these specific issues, so that I know, at least where the disagreements come from. Because sometimes experts are also working with different assumptions, and the parties give them different things to work with. So they are presenting oranges and apples because their starting point is different sometimes. So I think there are several ways of trying to, make the whole process of technical evidence a bit more efficient.
No, definitely. And I think this is also another important topic about, traditions on legal systems, because normally experts, party experts from at least a Brazilian perspective, they will be part assistants. They will be working for the party for them to make their cases. And the expert appointed by the tribunal, this figure is the one who is supposed to be independent in the way he approaches, the facts and gives his opinion. So there's probably a gap on the way how an arbitrator from Brazilian background approaches expert evidence given by the party, just because you will assume this person, this professional, is there, to corroborate and to confirm whatever the lawyer said about the case. So this is also an important cultural impact. But I'd like now to, yes, João?
João, just if I may jump in and make one additional comment. What I have been facing in some arbitration cases is the fact that, as Maria Claudia explained, after the party-appointed experts were examined during a hearing or presented their expert reports, then the tribunal, as Kabir said, facing two completely different reports, they then appoint the tribunal's expert, and then with more costs and more delays. So, and one thing that I would like to add is the fact that party-appointed experts lack impartiality, because they are not independent experts. So there are people who say that they are no more than paid advocacy of a party's cause. So it's like quite obvious that I don't know if at all the time, but in general, party-appointed experts will withhold information, or they will refrain from identifying some problems. And then the arbitral tribunal will be really confused. What should I do? And as a lawyer, I will complain with the additional costs and expenses, and that's something that is time-consuming. But there is no other solution than to the arbitral tribunal appoint its own expert. And from a law and economics standpoint as well, there is like this financial incentive for the party-appointed expert to render a conclusion or expert report in favor of the party who just appointed him or her. So for me, it's like, in general, and as a lawyer dealing with some of these issues, to maybe think, I know about this flexible approach, and it's really good to think about new ideas or to do this hot tubbing between the experts. But maybe we could just think that since the beginning, the tribunal's expert may give to the parties and to the arbitral tribunal a better, fast, and less expensive conclusion.
Yeah, fair enough. Now, actually, I would like to bring our conversation to a slightly different topic from what we spoke so far. That has all to do with virtual hearings. So the production mainly of oral evidence and witnesses, hearing witnesses. Now with the pandemic and the sanitary crisis, arbitration cases and court cases, they are being conducted virtually, electronically. Here in the Chamber Ciesp, we have had several cases being presented on their merits and, with the hearing fully in the virtual scenario. So this is very new for the whole community. Of course, in the past, we had some communication done virtually, and maybe, the terms of reference being discussed online virtually. But normally the day in court, if you like, or the day to present the case would be something done in person. And it might have an impact. So I would like to hear you about this issue, what you see, what you think about this trend, because of course it's not the same as being physically present in a place, but you can still make your case, you can still participate. And it definitely has an impact on costs and on time of everybody involved. So Maria Claudia, if you would be willing to start with this issue, I think it's interesting when we think about evidence, you know, of about what's going on now.
Sure. Yeah, I think, you know, the advantages of these virtual hearings are, of course, you know, connecting to the previous question, time and costs. You know, it's less expensive, and you don't have to wait for months until people are allowed to travel again. And it's probably easier to conciliate agendas as well, because people are on you know, don't have to travel. So this is something that is indeed an easier way. But the disadvantages, you know, the clear disadvantages, the lack of, you know, physical presence. And I think that having everybody in the same room, you know, seeing how the witness react, the body language of the expert, of the lawyers, these things, they can play a part in the decision-making process. And some value in physical presence, especially, you know, in merits hearings. But for me, the question here is, you know, are virtual hearings here to stay? And is there a real change of paradigm? And I think that when it comes to, you know, maybe hearings for provisional measures or emergency arbitrator proceedings, or, you know, those procedures of a more expedited nature, I think that virtual hearings will become the norm, you know, the rule. I think that they are already used to a certain degree in this kind of cases, and I believe that now everybody is more comfortable with them. It will be difficult to oppose or defend the need of a physical hearing when the timings are so short, and the nature of the procedure as such doesn't really justify a physical hearing. But other than that, maybe hearing for oral arguments only, you know, why not? I do think that we will at least consider this possibility instead of automatically assuming that a hearing has to be a physical hearing. But I also think that another interesting aspect of this discussion, and again, maybe here we do see a real change in paradigm, is no longer assimilating necessarily a hearing physical presence. As soon as the pandemic arose, people started talking about virtual hearings, and it was generally understood that, you know, we needed parties' consent to go virtual. And that was the first reaction. Without parties' agreement, no virtual hearing. And then I think that kind of the second step was, as you mentioned, that we started to see the terms of references giving the tribunals the power to determine whether a hearing will be virtual. It is still parties' consent, no, because they signed this document, but it's an ex ante of sorts consent. So before the discussion of when the hearing is happening, and maybe a moment in which the parties are a bit more agreeable to whatever the tribunal puts in front of them. But, you know, for example, in ICC arbitration, this discussion arises in light of the language of the rules. That I think that the rules say something like, when a hearing is to be held, the tribunal shall summon the parties to appear before it. There is this notion of appearance. And this has traditionally been interpreted, rightly or not, as mandating a physical hearing. But now the ICC is actually discussing amending this article in a new version of the rules that is to be published probably next year, which will expressly give the arbitrators the power to determine that a hearing may be conducted by video conference or any appropriate means of communication. So we will no longer assume that, you know, hearings are necessarily physical hearings. And I don't think we will completely migrate to fully virtual hearings. But I do think that, you know, hybrid hearings with some witnesses being examined by video conference, for example, will become more of a practice, and counsel and arbitrators alike will be more open to these possibilities.
Just to add to the Maria Claudia's comment, the ICC released just after the pandemic started the ICC guidance note on possible measures aimed at mitigating the effects of the COVID-19 pandemic. And it says that the Arbitration Tribunal should consider using either audio conference or video conference for conferences and hearings where possible and appropriate. So in this regard, ICC shows that a change of the paradigm is like in course. So I don't know, João, I'm sorry to interrupt, but there is like this clear evidence of a changing of behavior of a lot of arbitral chambers, and in particular of the ICC.
Definitely. Thank you, João. We felt the need at the Chamber Ciesp of editing a guidebook, orientations in general, soft law, made by the Secretariat of the Chamber, just to tell people what they are expected to do during the hearing. So what they should know before going to the hearing, how to prepare themselves in all sorts of aspects, going from dressing and how to appear because people are at their homes. So we need to tell them what's expected, to internet connections, things as not using open Wi-Fi connections or using private means of internet connections and all of that, to more specific details on telling them on when to switch on or off their microphones, on not interrupting because it's a different space from when you are presentially. So all kind of details. We felt the need on our daily practice to just give guidance. Of course, the power to conduct the proceeding it's with the tribunal, and those are the actors that should be presiding. But we felt there is still ground to cover, leveling all players in arbitration, because you have very sophisticated players who use very well, virtual tools and tend to be very good at that. And you have people who are very, who do not know much about internet or have never been in a virtual meeting. So I think it affects the work of everybody involved in dispute resolution. And with that in mind, Eric, we know that court proceedings in Brazil, they are electronic, but now we are having more and more hearing and cases being also presented virtually to judges and to second instance judges. So if you could just comment on your experience or what you're hearing with your peers, it would be great.
Yeah. First, I agree with everything that you guys said about our hearings. I think we're getting used to more time to understand all the facts, and also the judges are getting used to. But if I could add some a judge point of view with not dealing with costs and other things, we don't know exactly how our brain works. So maybe with visual hearings, we might miss some information, but also maybe we might reduce some implicit bias in judgments, for example. That's why I'm saying that we need more time to understand and to make more empirical studies about the outcomes of virtual hearings.
Definitely.
But I love the idea.
Sorry. No, I think that's something that has come to stay. I think we will get a stage in between in which we'll have some hearings being done physically, presentially, and others online, and also all forms of mixed figures. So we might have some people, presenting the case in itself, but have a witness who is abroad or in another city. So, the more we use these tools, the more different kind of combinations we might get. But still with that in mind, Kabir, I would like to hear you on a more international approach, US side of things.
On virtual hearings, look, I think I'm going to agree with all our prior speakers here. I think it's mostly going to be a positive thing. I think the world is becoming closer. Imagine a reality like this. I'm in New York. We have people from all over Brazil. We have somebody from London. This was the exception, not the norm. And it's bringing us all so much closer. I think just life at large, there's a lot of advantage, obviously, in meeting in person, but things like this connect us. So I see that as a positive thing. I just pick up on the point the judge made, because, there are some initial studies actually that tell us cross-examination, again, red flag, we're talking of a common law idea, but we're told that cross-examinations are actually better when you do them virtually, because you have a person's face that is blown up on your screen. And you can see when they shake in a way that you may not actually be able to see in reality. When a person's in a witness box standing far. Now, all this, as the judge said, is TBD. We are all figuring this out in real time. I think the one area where we will have difficulties in international arbitration is going to be really international disputes. If you have a case with an Australian party, an American party, a Brazilian judge, an arbitrator, and a French arbitrator, to find a time zone that can work for all the parties is going to be a nightmare. So I think the reality that you hinted at, I see that as being the future. We're going to come, hopefully, to some hybrid model. Some people in the room, some people virtually. That's what I think the future would be. But again, as our prior speaker said very eloquently, it's mostly a positive development. Cost advantages, even the environmental advantages, right? The less we get on a plane for business, it's probably better for humanity. For travel, we should do it. For business, if we can do it virtually, it's better. But I'll stop here.
That's true.
We also have another question now from our audience, from Paul Mason. Thank you so much, Paul, for your question. That is about the use of IBA rules on the taking of evidence in international arbitration, and to what extent those are referred to in arbitrations with Brazilian parties. I think that as we address this question, it's probably good to bear in mind that we also now have the Prague rules as a set of soft law that, well, claims or hopes to give more of a civil law approach to the whole aspect on international arbitrations. So, Kabi, would you be willing to explain us a bit about the IBA rules and the Prague rules in general?
I'm really honored to do so. Thank you, João. Thank you also to our audience who have been fantastic. I'm passively following the commentary on Facebook, and it's, you're such an engaged audience, so we're very grateful for that. The IBA rules on the taking of evidence, the title calls them rules, but they are guidelines. And these, I think the earliest iteration was like in the late 1980s, and every 10 years they're updated. The last update took place in 2010, and we're doing an update now. It is a voluntary organization that is supposed to be a marriage between civil and common law traditions, and they have representatives from both civil and common lawyers. They're not elected. I just put this for what it is worth. These are prominent people who get together in a room and make stuff up. But that's how these guidelines are effectively created. But I will note, there are a whopping total of 9 articles in the IBA rules. So that's your evidentiary framework. But I just connect this to Maria Claudia's initial introductory comment. Even though these are a marriage between civil and common law, using these terms loosely, they do have common law assumptions underlying them. Like, let's just call a spade. Document production is envisioned. Cross-examination of witnesses and experts is examined. I will not talk about Brazil because, I don't want to show my ignorance in front of a very enlightened Brazilian market. But the IBA rules have sort of become a go-to standard, a guideline standard, but in most international disputes. Very often procedural orders one will tell you something to the effect, we will refer to them even though we are not bound by them, So these have become fairly prevalent. And this is what a few years ago led to civil lawyers. Now, civil law is 80% of the world, right? Common law of a country is ruled by the UK at some stage. They're relatively smaller, so take civil law. This civil law was predominantly led by CIS, Russian CIS countries. I don't believe there was a Brazilian representative. There was a Portuguese representative, so there was a linguistic representation, but I'm not going to make the stupid assumption of saying Portugal and Brazil are the same. But this is supposed to be a civil law response. And where we started off, right, the assumption here is not adversarial. The assumption here is inquisitorial. The arbitrator / assuming the role of a judge will control and dictate the process in a much more active manner. Now, this has caused a lot of havoc to a lot of people, especially common lawyers who read it. A judge is going to do, the arbitrator is going to do what? The arbitrator is going to tell us what we can produce. An arbitrator will tell us who to call for cross-examination. World is ending. Personally, now, if you ask me personally, my view, and I think we are seeing this idea in this panel, anything that is giving choice to people, anything that is allowing people to have greater flexibility is a good thing. We should welcome it. Why is there a monopoly on one way of doing things? Most of the rest of the world is able to get along fine. So any alternative that we have, we can consider it, we can use it. What makes sense in your dispute? Think about that. So I put it out there as a suggestion, and I, of course, invite everyone to contribute. Joao, you have done your PhD on these topics, so you can weigh in too.
João, I want to hear you on the issue, because I know you have experience both with domestic arbitration and international arbitration, as with cases before Brazilian courts. And do you think that there are different approaches on these three levels, on IBA rules and all these international soft law? Does it have any effect on the way we do stuff here in Brazil?
João, so what I think that happens, especially in domestic arbitrations, in arbitration here in Brazil, is that in general, the arbitrators will use the IBA rules as a really strong guideline. Since the Brazilian Code of Civil Procedure does not apply to the arbitration in Brazil, unless, of course, the parties agree to it, one really good standard to be adopted, and the arbitrators tend to follow them, are the IBA guidelines. And as Kabir said, the IBA guidelines are generally adopted in international arbitration. But from a Brazilian point of view, in the Brazilian arbitrations, what I see is that the arbitrators are really using, and they tend to adopt it if there is a need, or if anything is not clear on how to produce a certain evidence, and in particular as to the production of documents. And just like a really quick note on the virtual hearings, because it's like a really trend topic, Kabir was like really precise when he said that flexibility is the word. However, I don't know if I'm a bit conservative. I agree to a certain extent, because in terms of reference, for instance, and I think that Fiesp is adopting a lot of virtual hearings since before the outbreak, to schedule virtual hearings to discuss the terms of reference. So it's a common ground, and it goes without saying that virtual hearings for terms of reference, and I think Maria Claudia told this too, are really quite common, and I don't see any problem with it. But hearings on the merits, it's like really tough for me to accept. I know that we have to consider the cost and the delay, but if the parties agree, or if there is like a really big issue to be discussed in a hearing on the merits, for me there is like no software able to replace the in-person eye contact. It seems to me, and I know that we just have preliminary studies, as Kabir said, and Eric as well, but as a lawyer, and I don't know if I'm getting notes, but it's like really important to be in an in-person hearing to assess the credibility of the witness, to cross-examine the witness and see in their eyes if what they are saying is the true or not. And I would like to address this to the Alto Tribunal, to show the Alto Tribunal that, hey, this witness is really like not telling the truth. And sometimes for me, virtual hearings or like these virtual meetings, they are good, but they are not like really precise, really the way to assess if what I am saying right now is like the true or not. So just like in short, I understand and I agree that flexibility is like really one issue to be considered, but maybe we have to think if for hearings on the merits, it is not better to, and of course, thinking about time and cost, but it's not better to schedule, if possible, in-person meetings, in-person hearings.
No, good, João. Just another note on the topic. I think your point is very good. I think that arbitration has everything to do with flexibility, especially when we are in exceptional times. So speaking from the standpoint of a Secretary General of an institution, what we try to do is to give the tribunals, the parties, the lawyers choices on how they want to handle their cases. So, and I think this is what a good arbitration chamber is supposed to do. So if the parties and the tribunal deem appropriate to have the case heard virtually, the tool is there for them to make good use of that. If not, we need to have the infrastructure to receive the case in person when that's possible, when that's feasible to do. So even in this exceptional moment, and we are living a difficult moment, an exceptional moment, it's really up to the parties and tribunal to decide what's best to their case. So the position we try to take is, provide alternatives. And I think this is probably a good place to be as an arbitration center. Because again, waiting, if it's better to, wait a few more months up to when we can open again our facilities, it's better for the case, or is it better to have the hearing now because of time and length of the proceeding? That's a decision really up to the parties in with the tribunals. And I think that in general, tribunals have been very careful even when determining virtual hearings. It's all been really discussed among all the players, everybody involved, just to decide what's better. But I think in general, and I can say that as a rough estimate, most cases are having online hearings now. So after a few months, even the cases who were waiting for dates in our schedule and calendar for presential hearings, those are now going to be virtual, just because we now got 4 months without any in-person activity being able to be done in Brazil. So it's things people need to bear in mind. But I did see Eric raising his finger.
Yes.
Please Eric. Sorry.
Thank you. No problem. I completely agree with you. And I was thinking about what João Marçal just said, and maybe it's just some path dependency bias, Marçal. And you said about, it's different. We never know if you can get everything, but thinking about some, I don't know, AI tool that will scan your face and pointing if you are lying, or I don't know, maybe in 10 or 50 years, this is going to be very natural for everyone.
No, yeah, I agree, Eric. And just like a fun story. So I remember a virtual hearing that I had, and just to point out that, in fact, a lot of times we have like issues with the internet connection, and all of these WebEx, Zooms, or related softwares are not like that good for now. So maybe in the future, the international, actually the intelligence will be in a way that we will not have any problem or face any issue to have virtual hearings. But for instance, I had a hearing that we faced a lot of internet connection issues to hear what the witness was saying, and it was like a CEO of a certain company. Luckily, it was not my witness. So after a long time, we only had the audio, and the CEO was telling a lot of bad words, saying, "Oh, this F word hearing, I don't want to be here." And then 15 minutes later, oh, everybody was hearing what he was saying, and the examination was like, okay, so now we are going to examine Mr. X, and his lawyers were, oh my God, so everybody now hates my witness. So just to conclude, we have to maybe wait a little bit more and assess the development of the tools and all of these softwares to host the virtual hearings.
It's true, fair enough. I mean, and speaking as an institution, it's something we cannot control the same way we do in presential hearings. Because, you know, at least in our case, most of the hearings, they are in our facilities. So our hearing center with our people operating the cameras, the secretariat is there taking notes. We control the room. And when we go virtual, we cannot provide the exact same thing just because we have people coming from different connections and then using the program we provided for the hearing. So you get problems. You might get problems in connection. You might get problems with these people who are not so used to the virtual arena. But I think in general the experience is very good. I'm very positive because we had a couple of weeks ago a hearing with 50 people, including lawyers and witnesses and tribunal and expert witnesses being heard as well. And it worked just fine. I mean, took a couple of days for the whole hearings to be held, but so Maria Claudia, I saw your hand coming.
I'm trying to behave just like Judge Eric instead of just jumping the gun and start talking. So I raised my hand this time. I think that also a positive point of the virtual hearings is that we are kind of learning how to better use time, because we cannot stay 8-9 hours in front of a computer and pay attention to whatever is happening in the same way. Our attention span is not the same in front of a screen. And also we have the issue that Kabir mentioned of different, time zones. I had an example of a hearing, not mine, but a colleague of mine, that started at 5 p.m. and went until 10 p.m. because he was in Spain and he had people in the US and China and I don't know where else. But they had basically a 5-hour day hearing, and they had to, make the best use that they could of these 5 hours. And I think that in these circumstances, you have to actually think, do I really need 2.5 hours for my, opening statements? Do I really need 3 hours with this witness? So, again, I think it's just, taking a bad situation and trying to think if there aren't better ways of just, doing the job that we do.
Yeah, well, I think this is all very good. We had a very good discussion. I wish we could continue, but as Maria Claudia said, the attention of the public online is not as good as in-person meeting. So we have to finish our webinar. And I just want to say to each and every one of you, Eric, Kabir, João, Maria Claudia, thank you so much for being with us. It was a really interesting afternoon. At least for me, I learned a lot with all of you. Thank you so much for coming. And I want to say massive thank you to all of you who watched, who participated in the meeting, sending questions, commenting. Great audience we had. This was another edition of the Chamber Talks. So stay tuned, do follow our social media and network. We'll have more content coming up in the forthcoming weeks. So thank you very much. Eric, Kabir, João, and Maria Claudia, thank you so much for your presence, for sharing your knowledge and insights with us. Thank you so much.
Pleasure.
Thank you.
Thank you. Thank you, guys.
Thank you, everybody.